Can the police confiscate your mobile phone and obtain the enormity of data that it processes and stores? The fundamental right to privacy and the fundamental right against self-incrimination occur the moment an individual's personal device is unlawfully confiscated. Either the police officers do not care for the rights of the accused, or they do not understand how digital forensics works. Typically, police ask individuals to unblock their phones and then hand them over to the police without any initial forensic procedures unless the device is formally seized. How is that the police do so? The legal principle that no one is bound to incriminate themselves underscores a fundamental right in the realm of privacy and the right against self-incrimination. This principle highlights everyone's right to protect their personal and private information and resist providing self-incriminating evidence. In the context of mobile phone seizures by police, this principle becomes particularly important. Mobile phones, which today store vast amounts of personal data, have become digital alter egos of individuals, deserving stringent protection from searches and seizures if the individual right to privacy is to be meaningful. Now, the authority to seize mobile phones and the legal boundaries and implications are interesting. In the celebrated case of Justice Puttaswamy, the Supreme Court of India observed that the right to privacy is an intrinsic part of the fundamental rights conferred by the Constitution. Mobile phones and smartphones in particular document and store every aspect of an individual's life, and it forms an extension of that person itself. The breach of fundamental rights, both the fundamental right to privacy and the fundamental right against self-incrimination, occur the moment an individual's personal device is unlawfully confiscated in the hope of obtaining personal information. Whilst Article 20 of the Constitution categorically protects an individual's right against self-incrimination, Article 21 bestows an individual with the right that forms an intrinsic part of living in a dignified way. Supreme Court has held that an individual's right to privacy is an intrinsic part of the right to life itself. So then, can the police confiscate your mobile phone and obtain the enormity of data that it processes and stores? The law requires that any search by an investigating agency must adhere to strict legal standards. The search should be conducted under legally established procedure, and police actions must be proportional to the aim or objective that is sought to be achieved in the investigation. In respect of a person who is lawfully arrested, the police and other law enforcement agencies retain the power to carry out searches upon the person and seize a digital device that may be available on such person. The police also has the power to issue written notices or demands seeking the production of a document or any other evidence that may be available. If the accused refuses to divulge his information, then the police may move the court to seek warrants for conducting searches and seizures to secure such documents. Law enforcement authorities must respect the rights of an accused during investigations, particularly in relation to self-incrimination. For instance, in the case of mobile phones seizures, even if there is an apprehension that the data revealed after entering in the password may be incriminating, the accused has a right not to divulge such passwords to the investigating agencies. The investigating agency will then have the option of seeking court orders for forensic examination of the digital device, which the court may grant if it has reasonable grounds to believe that the data so stored in the device would be secured during an investigation and would be crucial for the investigation itself. In today's age, digital evidence plays a key role, whether it is about interception or monitoring of information. In most crimes, digital evidence plays a key role for the prosecution. There are various provisions under the Information Technology Act that grant powers to the state. For example, Section 69 of the IT Act gives wide powers to a government to intercept, monitor and decrypt information, but then within the safeguards that are identified in that section itself. Especially in economic offences or crimes involving money laundering, digital evidence plays a key role in establishing a financial trail or tracking down the heavens for black money. There are special powers granted to investigating agencies in such cases for warrantless searches and seizures. For example, in crimes involving drugs and other psychotropic substances. Agencies like the Enforcement Directorate have special powers to confiscate documents and carry out searches and seizure operations. But then, can the Indian police seize an individual's mobile phone at any time they wish? Of late, there have been series of high-profile cases involving Bollywood celebrities, businessmen, and other persons of interest which have highlighted the issue of police seizing and searching personal digital devices such as smartphones. These cases often involve leaked chats from WhatsApp or other encrypted platforms after device seizures. Typically, police ask individuals to unblock their phones and then hand them over to the police without any initial forensic procedures unless the device is formally seized. How is that the police do so? What this necessarily means is that in a majority of cases, either the police officers do not care for the rights of the accused or they do not understand how digital forensics works. The Karnataka High Court has recently laid down extensive guidelines for searches and seizures of electronic devices. The court elaborated on how and when should the police collect digital devices and what kind of protocol must be followed. Now, in case the police collect evidence in an unauthorized manner, will such evidence be admissible in a court of law? There is an active debate across the world on whether such evidence should be admissible, in contrast to the fruits of the poisonous tree doctrine in the United States of America and the unfair operation rule in the United Kingdom, which both exclude illegally collected evidence from being admissible. The evidence law in India does not impose such an absolute exclusion. Indian courts have the discretion to admit evidence obtained through illegal searches or seizure if it is deemed relevant. The Supreme Court, in a matter considering this aspect, held that unless explicitly prohibited by the Constitution or by any other law, such evidence is indeed admissible. The court based its decision on the absence of a recognized right to privacy in the Indian Constitution at that time. However, this reasoning of the court was significantly altered by the 2017 landmark judgment of Puttaswamy, which recognized the right to privacy as a fundamental right. The 9-judge Constitution bench of the Supreme Court in Puttaswamy affirmed the right to privacy as a fundamental right and as a right forming a part of human dignity itself. The judgment firmly established that any invasion of privacy must pass the threefold test of legality, necessity, and proportionality. This shift implies or suggests that the fruit of the poisonous tree doctrine could now apply in India, emphasizing the importance of legal standards in evidence collection. This could lead to a conclusion that evidence illegally collected will become inadmissible. There is a need in balancing investigative interests with the fundamental rights of an individual. The Supreme Court held that in certain forensic tests such as narco analysis, polygraph tests, and brain mapping, etc., they violate the individual's right under Article 20, Subclause 3 and Article 21 of the Constitution, that is, right against self-incrimination and the right to life itself. The court therefore mandated that these tests could be only undertaken with the prior informed consent of the individual and under judicial oversight, thus providing a legal framework to protect the fundamental rights of an individual whilst at the same time allowing the police to use such technology and tests in future in the process of investigation. The Delhi High Court in a recent judgment disregarded illegally intercepted audio recordings and set aside the charge based on such evidence. Although the court did not explicitly discuss the fruit of the poisonous tree doctrine, this decision sets a precedent for advancing the jurisprudence on excluding illegally obtained evidence in India. The United States Supreme Court has invariably come to the rescue of its citizens whenever surveillance activities have resulted in an intrusion into the realm of individual rights. When an individual has a reasonable expectation of privacy, then that privacy cannot be breached unless a legal process has been followed. Accordingly, the Supreme Court of the United States of America held that surveillance activities conducted by the state constitutes an unreasonable search under the US 4th Amendment. For example, surveillance by way of installing listening devices outside a public telephone booth, electronic tracking devices or beepers being installed, thermal imaging devices being used, global positioning system tracking or GPS tracking devices being installed on vehicles, or even cell phone recordings to be considered without the consent of the individual. All of these have been considered as unreasonable intrusion into the privacy rights of an individual, even where surveillance was targeted and was commenced on the basis of a reasonable suspicion of criminal activities. In the celebrated case of Riley versus California, the United States Supreme Court assessed the constitutionality of a warrantless search of an individual's cell phone, despite the US government's argument that searching for electronic data on a cell phone was similar to searching a physical wallet of an individual who was detained. The court disagreed. It extensively analyzed modern cell phone capabilities to store and process vast amounts of personal information and concluded that they could reconstruct an individual's private life in its entirety. Consequently, the court mandated the requirement of a search warrant before examining an individual's cell phone or smartphone. The judiciary's proactive role in establishing legal frameworks and guidelines underscore the importance of protecting fundamental rights during criminal investigations. The aforementioned decisions demonstrate the court's commitment to upholding constitutional protections whilst at the same time enabling law enforcement agencies to perform their duties effectively. These precedents provide a robust legal foundation for future cases, ensuring that individual rights are respected in the investigating process. Recently, while passing orders in a public interest litigation, the Supreme Court directed the Home Ministry to come up with guidelines on confiscation of digital devices such as mobile phones and laptops. However, nothing concrete has happened as of now in this regard, and the matter remains pending for consideration. The search and seizure of electronic devices by law enforcement authorities have wide-ranging implications on the society and on individual liberties. It creates a sense of fear in the minds of people and only empowers the state to trample an individual's right to privacy. Although the ability to search and seize a mobile phone is crucial for modern law enforcement, it must be carefully regulated to protect individual privacy rights and individual self-incrimination rights and prevent the abuse of state power. Clear judicial framework and judicial oversight are essential to ensure that the rights of individuals are not undermined in the pursuit of crime prevention and investigation.